This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Whatever the incident that has happened, it's a very unfortunate incident. Should not have been happened. I will not justify that incident because there are some things which cannot be justified and ought not to be justified. As an officer of the court, I should not justify. But whatever happened, I can tell you, Lordship, one thing that has, I will not say frustration, but what has happened is a circumstance. They are victims of this circumstance. They have been agitating for the past 4 years, 5 years. They are waiting because they are recommended candidates. They all are recommended candidates, and because of an interim order, the entire selection process has been stalled. So obviously they were expecting that the matter will be heard out. And when the state was ready to give appointment, they were expecting that something positive might come out. But because of this interim order and everything, because of several adjournments that were granted, that is the only thing which might have triggered everything. It can be out of frustration, it can be out of some completely out of frustration. They are the circumstances beyond their control, Your Lordship. They are financially insecure, they are mentally insecure, they have families, and I can assure Your Lordship one thing, it was never their intention to dishonor or malign this honorable institution. They were organizing a peaceful protest, that is all. The allegations that has been given against my client of stampeding or stepping upon the picture of an honorable judge, I completely deny that. Because none of them either have brought the pictures or they were even near when this incident happened.
But while arguing, Mr. Bandyopadhyay had cited pictures, photographs. From those photographs, while he was seeking to argue that some of the counsel for your other sides, they are political persons and all, and they had been holding press conferences with the same persons. While saying so, he placed reliance on certain photographs which show that at least the first contemner was present in all these pictures. So therefore, isn't that a tacit admission?
Not an admission. With all due respect, Your Lordship, that is not an admission.
We have photographs annexed to the affidavits.
Met Mr. Ghosh.
Not Mr. Ghosh only. Photographs of the judge being cited, and there are pictures of stampeding also. Lordship, stamping on the picture. This is
7 contemners, Your Lordship.
Tisha Guho's affidavit, if you look at, in CRLCP number 7. What was the occasion of showing the photograph of the judges? In every hand there is a photograph of the judge. Must not have been eulogizing him or felicitating him. So his photograph was put up. We see the next photograph, stamping. It's a bit smudged, but the contours of the photographs can be made out if compared with the previous page 10 and 11. If you see the one encircled in red, the person with the green shirt on is stamping on a photograph. If you compare with the previous page, the concerned judge's photograph, it is decipherable from that. And it's in the same, there is no case made out that any other photograph, somebody else's photo. These are the photographs which are held high.
Yes. So, should kindly have a look at the photograph. He was standing beside the photo. He was not stamping. He was not stamping on. He was just standing.
Both his feet on both sides and the photograph on the ground. Standing.
The picture, someone must have brought the picture must be lying.
Picture was lying there, he was standing.
He did not stand, he was standing over there. That is my defense in my...
This militates against your lip service of apology. This specious defense.
So I started by saying...
Everybody who is frustrated will set a bad precedent like this then. Whenever I am frustrated with you, I'll just take your photograph and throw it out and give a press statement or whatever. I'll make an agitation before the judge. See, this is the rule of law we are trying to protect, not a particular judge. It's the institution. Institution has been cliched now. Not exactly the institution, the people themselves. We don't enjoy divine power. Constitution empowers us. It's by for of the people. The people have empowered us to protect them. We are the last defense. Bastion of defense is the judiciary. So if this is done in every case where there is a frustration because adjournments have been granted as per your submissions, we are confining ourselves to yourself. This frustration, where does it end? You are stamping the photograph, you are putting, holding the photograph up of the judge. Then if this is not administration, defiance of administration of justice, obstruction, what else is? He is in season of the matter and you are holding photographs. You are trying to browbeat the judge. This is a clear attempt to browbeat the judge before whom a matter is pending so that the decision goes in your favor. How can you defend this? We can't understand. This person with his both his feet apart, he's standing almost akimbo with the judge's photographs in the middle of his 2 feet. He was not aware there was a photograph there. The previous photograph shows it's in the hands of the persons present with him. Is it credible? What was the occasion of he's standing on that photograph? It was lying on the street. It flew from the air.
What has happened should not have happened.
Why are you trying to defend this? You say that the photograph might have been lying there and he was standing it. He's not stamping.
That is why I started my submission by saying that what has happened should not be justified. There are things that should not be justified, cannot be justified.
If it cannot be justified, you go to jail then.
You
cannot justify your activities, which is palpably against the institution. A matter is pending before a judge. Nothing personal, no personal allegation against him. Everything regarding that matter. So whenever a matter is before a judge, and there will be a show outside, and people will stamping on his photograph just because he's granting adjournments on the prayer of a particular party.
So the photograph reveals some of my clients or 2 or 3 of my clients who were present there, or all of them were present there. But
what did they go to do there? A picnic?
They were there. They were there. The photographs reveal that they were there. I cannot say that.
What is the reason for their being there? You have to explain yourself.
Reason being this protest that was being
protest was being. In that protest, you are holding up photographs, and the next scene we see is that photograph is behind the feet of somebody, and all of them. I mean, those are lying astray on the ground.
Apart from my client, I'm not justifying, but apart from my client, there were several others also who were holding the photographs.
If their names, will send them to jail also. We have no qualms on that.
I am not here to give anybody's name. I am here to just apologize for your lordship. What they have done wrong. Admittedly, what they have done wrong.
Every matter cannot be effaced. Every matter cannot be purged merely by giving apology. You do something of what sort? Not a criticism. Even fair criticism bordering on unfair, we can understand. We just ignore those things. That is happening every day. Even in a pawn shop, there are discussions about the judges after the live streaming. So we are not bothered with those things. But you are holding a photograph in your agitation. You're holding a photograph of a particular judge, putting it down the next scene. It's lying under your feet. Now, if this is not contempt, then what is? Tell us. After that, giving post facto apologies won't do. Then in every case, everybody would do that. Your frustration balanced with the rule of law, we have to take it into consideration. Frustration, up to what extent can the frustration go?
It's a frustration, no doubt. They are victims of the circumstances.
What circumstances? And adjudication has been given by the division, by a single judge, division bench, affirmed up to the Supreme Court. So that is the law of the land. An adjudication that some people are tainted, some are not, whatever.
That is not related to supernumerary.
This is the fallout that was linked by Mr. Banerjee with supernumerary.
No. The matter which travelled up to the Supreme Court, the Boishakhi Bhattacharya matter that relates to 9, 10, 11, 12, Group C, Group D, non-teaching, teaching staff. Now, this is the supernumerary post
that was created
on 19th May 20.
The allegation is that they were in the matter. The allegation is that they were the supernumerary posts were created because that is the allegation. Mr. Banerjee was saying that he named 2 or 3 counsel. And those counsel were with these people when that happened, and subsequently assured that no, will move a matter. That is, we are entirely adopting from Mr. Bandyopadhyay. And then this litigation was filed. Filed against what? Supernumerary post to absorb those people.
Challenging the notification.
So therefore, the other advocates took a stand diametrically contrary. Therefore, this supernumerary post is a continuation of that legacy of the previous judgment.
No, no, no. Supernumerary was never under challenge before the Honorable Single Bench or the Division Bench or the Honorable...
It was not. Certain appointments were. The entire appointments were set aside. After that, these supernumerary posts were created. We are not so naive.
Certain posts were created by a common order, common notification, certain posts to accommodate those persons who were creating or something in that selection.
Yes.
That was the subject matter of challenge before the honorable. That was the fallout of a challenge. But this particular so far as upper primary issue is
that was never covered by the previous.
These persons are the listed candidates of all the for whom 1600 posts need to be created for accommodating listed candidates, not those persons. And that 1600 posts all being created, what we are not just now falling to the the manager was submitting council was there, their meetings and their
yes.
It is just in support of the creation of 1600 and these people will be accommodated. I have no problem. Thereafter, litigation came to the fight. On the date, we were supposed to get the appointments, 1600 posts. Those were not accommodating 1600 listed candidates in court education and physical education. Writ petition, which was the subject matter of justice process, which in fact is the
these people were not covered by the previous one in any manner.
Apart from a common notification whereby 1600 posts were also created by the same notification.
But that was also set aside.
So
in the interest notification.
That is to be under challenge.
Mr. Bhattacharya, whatever may have prompted this kind of conduct, be it frustration, be it mental insecurity, instability, financial insecurity, the question is whether what they have done amounts to criminal contempt of court. That is the thing we have to decide. After that, if we hold them guilty of contempt, the question of whether we accept apology or take it as a mitigating factor, that will come later. First, we will decide. So we will hear you if once Mr. Mojumdar finishes. Yes.
And there was a direction in the division bench
Mr.
in respect of supernumerary post itself. And that was went up to Supreme Court. Supreme Court upheld the division bench order. So for supernumerary investigation,
we'll hear it. We'll hear it.
Supreme Court has stayed the CBI investigation. Honorable Supreme Court has also stayed that CBI investigation.
And you continue.
Supernumerary or Group C, Group D, that is not the issue. The issue is whether my client's conduct is worth of an apology from this honorable court or not. That is the only issue. Things have happened, it should not have happened. Obviously, this is a very serious issue. But taking into consideration their plight, I would kindly request your lordship to grant them apology. And also they undertake that this will never happen in the future.
Next. No.
One of the contenders is CRLCP 7. Mr. Kumar, assisting Mr. Bandhu.
Oh, you were assisting Mr. Bandhu. I see.
One thing is, supernumerary issue that is troubling your lot. Supernumerary issue.
Different.
9, 10, 12, the division bench judgment give some observations. Insofar as creation of supernumerary to accommodate those wrong candidates. That was put to challenge for the Honorable Supreme Court. Supreme Court by the order, that is the 17th. There are two orders. There are 3rd April 2024 and the subsequent order. The 3rd April order, their lordship desired that we will hear this aspect regarding initiation of CBI inquiry separately and kept it on the following Tuesday. In fact, on the following Tuesday, for these persons, of the wait-listed candidates and everything, incidentally, we just filed an application just to be on record before the Honorable Supreme Court that these part is different from the usual selection that is gone into by the Honorable The Honorable Speaker set aside the portion of the order by the CBI direction was set aside. And without the main matter remained as it is. This 1600 creation, this supernumerary for this 1600 is under challenge in the writ petition, which is being heard by the Honorable Speaker. Nothing. And in that one, on the first instance, without including these persons as parties, an interim order was made by this Honorable Court, the effect of the creation of this supernumerary, nothing else. And that interim order was continued. That interim order continued for a substantial length of time. It is only on the intervention of a division bench that today the matter is now being proceeded with to the extent of locus standi of the petitioners and actually Mr. Bandabadhyay for these persons.
Anybody else for the contemnor? Otherwise, we'll hear learned advocates in support of the contempt motion. Who will address first?
So far, we are concerned. I am led by Mr. Sengupta Millat.
He's not here today.
Oh, he will be coming after
time also today. We have run out of time.
Sengupta will be coming after 25th.
No, we are also not available.
He's not likely in the next 3-4 weeks. At least 2-3 weeks, definitely.
No, this bench is also not available. One of us will not be in Calcutta.
You need not take the pen.
You
need not take the pen.
So I had a talk with him. He said that after 25th.
6th of August. 6th of August. এই যে দেখুন মিস্টার বন্দ্যোপাধ্যায় আগের অর্ডারটা কোথায় আগের অর্ডারটা দাও Mr. Bandabadhyay, learned senior counsel, representing the respondent number 8 in CRL CP 7 of 2025, concludes his argument. Paragraph. We have also heard Mr. Pratit Mojumdar.
Pratit Mojumdar.
কোথায় পাবো রে?
Pratit Mojumdar.
এখানে কোথাও নেই তো দেখছি।
Mojumdar. 21শে জুলাই।
Pratit Mojumdar. Acha, for the appearing for the alleged container numbers 1 to 7. Stop. Paragraph. List this matter once again. List these matters, Karo, once again. On August 6, 2025, marked 12:30 p.m.
If it is possible for your lordships to keep it around this time, around 3-ish.
2 p.m.
2 p.m.
2 থেকে 4:30 অবধি হলে ভালো হয় না? আমার কোনো শেষ তো তুমি বলো আমার থেকে বলছি অসুবিধা নেই। 3:30
Or in the second half.
Very good. 2:30 p.m. Hey, Kaushik. Very, very bleak.
Copy gulo chain hai. But a one line may be added, Millet, what they're relying upon, the affidavits, whatever is not been.
Mr. Mojumdar has who? Mr. Bhattacharjee or Mr. Mojumdar?
So far as contemner number 8 is concerned, Millet, we have received.
Mr.
1 to 7, Millet, we have not
He
received.
has said so in front of us.
Fair
We'll
enough.
give it.
Fair enough.
সব কপি করে
Sure.
তারপর সুবিধা হবে।